Have you ever wondered if an employer can treat you differently just because you are pregnant or might become pregnant soon? It is a question many individuals face, and understanding your rights is incredibly important in the workplace. Pregnancy discrimination in the workplace happens when an employer treats an applicant or employee unfavorably because of pregnancy, childbirth, or a related medical condition. This is a form of gender discrimination, and it is illegal under federal law. It can affect anyone who is pregnant or has recently given birth, whether they are a woman, a man, or a non-binary person who carries a pregnancy. The core mechanism behind this protection comes from the Pregnancy Discrimination Act, or PDA. This federal law was passed in 1970. It as an amendment to Title VII of the Civil Rights Act of 1964. The PD specifically prohibits discrimination based on pregnancy, childbirth, or related medical conditions. This means employers cannot refuse to hire, fire, demote, or deny promotions to someone because of pregnancy. Furthermore, the Americans with Disabilities Act Amendments Act, or a DAAA, might also offer protections if a pregnancy-related condition qualifies as a temporary disability. This is crucial because it ensures that pregnant workers are treated the same as other temporarily disabled employees. For example, regarding modified tasks, alternative assignments, or disability leave. Your employer must treat you just as they would any other employee with a similar ability or inability to work. To protect yourself, it is essential to document any instances where you feel you have been treated unfairly due to pregnancy. Keep records of dates, times, specific actions, and conversations. If you notice a change in your responsibilities, a reduction in pay, or an unusual disciplinary action after disclosing your pregnancy, note it down. You can report these concerns through your company's Human Resources Department or directly to the Equal Employment Opportunity Commission, known as the EEOC. A common misconception is that employers are obligated to provide light duty for pregnant workers automatically. However, the PD clarified that if an employer provides light duty for other temporarily disabled employees, they must also provide it for pregnant employees with similar restrictions. This is known as the comparative treatment principle. Another key point is that employers cannot force you to take leave if you are able to work, nor can they exclude you from job duties unless your pregnancy genuinely prevents you from performing the essential functions of the job, and no reasonable accommodation is possible without undue hardship. Understanding that pregnancy discrimination is illegal empowers you to advocate for fair treatment and equal opportunity in your workplace. By knowing your rights under the Pregnancy Discrimination Act, and potentially the Americans with Disabilities Act Amendments Act, and by documenting any concerning behavior, you can ensure that your pregnancy does not become a barrier to your professional growth and well-being. This knowledge is your shield, helping you navigate your career path with confidence during this significant life stage.